Hello, my name is Jim Potts and I work for Illinois Department of Commerce and Economic Opportunity. Today we're going to do a presentation on Workforce Innovation and Opportunity Act WIOA eligibility. We're going to first cover general eligibility. So regardless of the title, if you're working with adults or a dislocated worker or a youth, all clients must meet general WIOA eligibility. WIOA itself became law in 2014 and became effective July 1st, 2015. There are a number of commerce policies that's going to be relevant and referenced during this presentation. You have WIOA general eligibility, selective service, adult eligibility, dislocated worker eligibility, general youth eligibility that covers also out-of-school youth and in-school youth. You have the low income, service priorities, basic skills deficiency, and veterans priority of service. Besides the state commerce policies, we also have direction out other than the legislation itself from Department of Labor. One is under Training and Employment's Guidance Letter, Teagle 1916, which provides the guidance to the adult and dislocated worker. And the other is the Teagle 2116, which provides guidance for the youth program. Both were sent most recently in March of 2017, and that is the latest guidance from Department of Labor. You'll notice at the bottom of this screen, there's a URL to the Apprenticeship resources page. That is a really useful page, and on that, you'll see a link for eligibility documents that includes all the federal and state policies and guidance that I just referenced. Before we get into eligibility, it's important for us to recognize that U.S. Department of Labor put out guidance on handling and protection of personally identifiable information, PII, under Teagle 3911. Let's discuss a little bit more about protection of PII. Illinois state law has guidance under the Identity Protection Act, as well as Personal Information Protection Act, and the Illinois Data Security on State Computers Act. Also, in the WIOA final rule legislation, it gave guidance about recipient and subrecipients of WIOA Title I funds must have an internal control structure and written policies in place to protect PII and sensitive information. There's further guidance under federal uniform guidance in the legislation. It says that they must take reasonable measures to safeguard protected personally identifiable information and other information the federal awarding agency or non-federal entity designates as sensitive. And then you also have further guidance in the Teagle 3911. It requires by the Department of Labor that grantees must have policies and procedures in place under which personnel, before being granted access to PII, acknowledge their responsibilities for safeguarding data. It's really important to understand that when your client's coming in to get services, you're going to be capturing a lot of personal information from them, as well as about their family. So we must safeguard that information. Talk a little bit more of the definition of PII. PII is information that can be used to distinguish or trace an individual's identity, either alone or when combined with other personal or identifying information that is linked or linkable to a specific individual. And there's a similar definition to PII in the uniform guidance of the WIOA legislation. So let's speak about what is protected PII. That's information that, if disclosed, could result in harm to an individual, according to the guidance within the WIOA legislation. This does not include PII that is required by law to be disclosed. So when you're thinking of protected PII, probably the most known is the Social Security number. So if a client's Social Security number gets exposed, some folks could do some unscrupulous things with the individual's personal information. Then you also have what's called non-sensitive PII, and that's information that's disclosed by itself could not reasonably be expected to result in personal harm. But what will happen is individuals can take some of the protected information along with the non-sensitive information. So maybe you have a client's social security number, and they also get the address that goes along with it and the client's birth date, and they can open up lines of credit. So it's really, really important that we're safeguarding our clients as well as our clients' family information that is being provided to us to determine eligibility for their program that they've applied. Some other things about protection of PII. PII and other sensitive information must be protected at all times, so you don't want to email sensitive PII unless it's encrypted. Don't store sensitive PII on portable drives or media unless it's encrypted. Don't access or store PII data on personally owned equipment at off-site locations. Access to any PII created by the ETA grant must be restricted to only those employees who need it in their official capacity to perform duties in connection with the scope of work within the grant agreement. So nobody should be looking at your client's personal information other than those that need it. So you're looking at yourself as the staff that's working with the client, and then maybe a monitor or a boss that's providing oversight, but nobody else should be looking into the files of your clients to find information about a client. Bottom line, you must keep all your clients' personal information protected from unauthorized personnel. So now let's get into general WIOA eligibility requirements. As I mentioned earlier, Commerce has its WIOA General Eligibility Policy 5.1.1, and it covers all titles, regardless if it's adult, dislocated worker, youth. All clients must be authorized to work in the U.S. before they could meet WIOA General Eligibility criteria. Also, all clients born male who have turned age 18 and were born on or after January 1st, 1960 must be compliant with Selective service before they can meet WIOA general eligibility. So let's speak more about authorized to work in the United States. Participation in programs and activities is limited to United States citizens, lawfully admitted permanent resident aliens, lawfully admitted refugee and parolees, and other persons authorized by the Attorney General to work in the United States. The information about authorized to work is captured within the application on the demographics and contact information screen. And on there, it's simply a question that states, are you authorized to work in the United States? So if it's populated with a yes, it's going to bypass the internal logic to support this portion of the criteria. But it's really important to understand what the client's saying yes. What this is saying is they have an unencumbered ability to work in the United States. I mean, there are no restrictions. So if somebody has an INS card and it restricts them to just working for one company, well, those are restrictions. So you'd want to look really closely at that. Other things that you want to have consideration for is if somebody is on an INS, the immigration cards, and maybe it has an expiration date that's came up or it has been expired, well, you have to look to see if they are authorized to work in the United States. So those are some of the keys that you want to make sure you're looking at. And at time of eligibility determination, staff are going to be responsible for collecting documentation to support that the person does in fact meet the criteria of authorization to work in the United States. Here's an example in the slide shown of the different acceptable documentation that could be used to support authorized to work in the U.S. Next, we're going to speak about Selective service compliance. For all males who were born on or after January 1st, 1960, when they turn 18, they're required by federal law to register with Selective service. If the apprentice applicant is a female or a male born prior to January 1st, 1960, the Selective service compliant question is not part of the application. If the apprentice applicant was born a male under the age of 18, Selective service registration is not required at application. For those required on the apprenticeship application on the demographics and contact info screen is where the information about Selective service is recorded. It's a simple question, are you registered with Selective service? And it's a yes or a no. If the no is checked, the individual would not be eligible for any WIOA program. If it's a yes, then there's going to be a requirement to record the Selective service number. If a client was born a male and is between the ages of 18 and 25 and is not registered with Selective Service, he can go to the link registration with/verify Selective Service and register with Selective Service there. The Selective Service number must be included as part of the application for all individuals who are born a male with a birth date on or after January 1st, 1960, who are compliant with Selective Service. So what we want to do is demonstrate in the next few slides how you're going to find that Selective Service number, because more than likely the individual will not remember or know their Selective Service number. So when you go into the Selective Service link that's right in the application, you'll notice that it does have the opportunity to register. So for those who are between the ages of 18 and 25 who have not registered, they can complete that then. For those who have registered, we just need to verify the registration and get their Selective Service number. You'll see the verify registration. And then when you scroll down that same page, it'll have the place where you put in the client's last name, the SSN of the client, and the date of birth. And then you have to prove that you're not a robot, and then you'll end up giving the Selective Service number. So once the search is completed, it'll look like this example. Now in this case, I end up using my own information. I changed my last name and just put in apprentice, but I put in my social and my date of birth, and when I proved I wasn't a robot, and on the right side it shows my Selective Service number. So in this case, if I was the client, you would take that Selective Service number and you would transfer it into the apprenticeship application. And then you would print out this verification, and you'd have that in your hard copy file to support Selective Service compliance. This slide just speaks about doing those steps I just spoke about. Taking that number, we're going to transcribe it over, and you're going to print out that copy of verification documents. And here's an example of putting that number in. A couple of helpful hints about the number of Selective Service. The Selective Service issues numbers. If a person was born the last 2 years of their birth year, those are going to be the first two numbers of the Selective Service number. So in this example, I was born in 65, so my Selective Service number began with the number 65. Below is an example out of the Illinois WorkNet of the documentation verification choices that are available to choose to support Selective Service compliance. You'll notice towards the middle portion, Selective Service Verification, www.sss.gov printout, that would be appropriate for what we just demonstrated, since that we got it through the system. Below are examples of both Selective Service and Authorized to Work in the United States documentation verification for an apprenticeship application at time of eligibility. You'll see it has the Selective Service, and in this case it stated we did use that printout verification, and then for Authorized to Work, it was a United States passport. Now, if a male client was born on or after January 1st, 1960, and they are now age 26 or older, and they are not compliant with Selective Service, they will not meet WIOA general eligibility criteria. So now, as long as this individual does meet Authorized to Work in the U.S. criteria, the individual could still be served under the apprenticeship expansion as a non-WIOA qualified. He would not be able to get certified under a WIOA certification of adult, youth, or dislocated worker. Something else we want to cover for general eligibility is the veteran's priority of service. Commerce, we have policy 5.7 and 5.7.1 and 5.7.2 that is the guidance on the various veterans and veterans priority of service. Let's examine this a little bit closer. Some of the key definitions are veteran, qualified spouse of a veteran, and transitioning service member. On this poster that's showing on the slide, it is part of the Commerce policies. And as I mentioned, those are at the apprenticeship link that I'd shown earlier. All the policies are, including this poster. This poster is supposed to be posted at a point of entry of any program that is partially or totally funded by Department of Labor. Since these apprenticeship expansion grants are funded by Department of Labor, this poster should be available at all points of entry when we're meeting with clients. Some of the key definitions of covered person. The covered person includes the eligible spouse or the veteran or a transitioning service member. Now let's discuss what are the requirements to be a veteran. For priority of service to be a veteran, the individual had to serve on active duty in the military, meaning that they went on active duty, they served at least one day on active duty, and then they must have a discharge other than dishonorable. So if somebody has a dishonorable discharge, they would not be considered a veteran for priority of service. But any other form of a discharge other than dishonorable, as long as they went on active duty at least one day, they would be considered a veteran. Now, eligible spouse of a veteran, it's a little trickier. It's not just somebody who's been married to somebody that's been in the military. To be an eligible spouse, you have to be the spouse of a veteran who dies of a service-connected disability or died while a total service-connected disability per a VA evaluation was in existence, or the spouse of a veteran who is missing in action, captured, or forcibly detained by a foreign power for more than 90 days, or the spouse of a veteran who has a complete service-connected disability per VA evaluation, meaning 100% service-connected disabled. So those are the criteria for eligible spouse. You probably will not find a whole lot of folks that end up running into the criteria of eligible spouse, but if they do, they are eligible for priority of service under the Veterans Priority of Service. So what does Veterans Priority of Service mean? If you have an individual that is a veteran or a qualified spouse of a veteran or a transitioning service member, and the transitioning service member is somebody who's in the process of getting out of the military, they're considered a covered person. However, it's really important for WIOA eligibility, the covered person is not an eligibility factor. The individual must still meet eligibility for a particular program, either an adult or a dislocated worker or a youth program, to receive Veterans Priority of Service. So what does Veterans Priority of Service mean? It means that if an individual meets the criteria, the individual gets front-of-the-line services, first opportunity, and if opportunities are limited due to funding, the LWIA/grantee staff must ensure the covered person receives services before an individual who does not meet Veterans Priority of Service requirements. So in this case, if you've got a qualified veteran or qualified spouse of an active duty veteran or a qualified transitioning service member, they meet eligibility criteria for one of the programs, they must be served before somebody who is not a veteran or qualified spouse or transitioning service member. In the apprenticeship application on the demographics and contact info screen, under military status is where the information about veterans or transitioning service member would be recorded. You'll notice it has active, veteran, and discharge. So active could be considered a individual who's a transitioning service member. A veteran would be, as we've discussed, somebody that's went on active duty at least one day and has a discharge other than dishonorable. I guess the same could be for discharged. On this case, the status of qualified spouse of veteran is not captured in the apprentice application. So if the individual who meets WIOA eligibility criteria and does meet that criteria of a qualified spouse of veteran, it should be recorded in the case notes, and the documentation to support the claim of qualified spouse of veteran would be kept in the hard copy file of the record. And then if the individual meets any WIOA eligibility criteria, the qualified spouse of the veteran should get priority of service. In conclusion, for all titles of WIOA eligibility, it is important to realize protection of personally identifiable information is of the utmost importance. All individuals must be authorized to work in the United States. It's very important to understand the intricacies of selective service for any client that was born a male who was born on or after January 1st, 1960 and has turned age 18. And then lastly, Veterans Priority of Service is required to be followed for every Department of Labor funding program, including and not limited to the WIOA and the Apprenticeship expansion grants. This concludes the presentation on WIOA general eligibility. If you have any questions, you can feel free to contact me at james.potts@illinois.gov, or you can phone me at 416-7097. Thank you.